อยากมาช่วยเลย
Okay, you guys ready?
Yes.
All right. Bridget will. Ready?
All rise. Court of Appeals for the state of Texas is now in session. Case before the court is Wyatt Reed versus Caroline Walker. The appellant and the appellee are each allocated 32 minutes to present their case.
Okay, please be seated. Good afternoon. Welcome to the Court of Appeals today. Could I have names of everybody? Our sheets first, who's the appellant, who's the appellee?
We are the appellant, Your Honor.
Okay.
My name is Insha Mehta. That is I, N for Nancy, S-H-A, M for Mary, I-T-H-A.
Okay.
And my name is Alex Shaw, A-L-E-X, and then Shaw spelled S-H-A-H, and we will be representing the appellant.
Okay, who's this first speaker?
No.
Okay, okay.
Okay. And you're also the appellant?
Yes,
Okay, and I'm Alex Shaw.
Yes, Your Honor.
We will be representing Appley in this proceeding. I'll
Oh,
present-
there's your name right there, okay.
Yes.
Got it. And who's, oh, you're the first speaker, not,
Blake,
Butler?
sorry.
I'm Miss Butler, Nadia
Okay.
Butler. I'm the first speaker for
Okay.
issue 1.
And for the sake of introduction, I'm Stephanie Aguirre, and I'll be speaker number 2 for the appellate.
all right, and would the appellant like to reserve time for rebuttal?
We would like to request 3 minutes for rebuttal.
3 minutes? I understand we're doing 32 minutes total
Yes.
per side, okay. So 3 minutes total for each one of you, or?
Only I will be doing about
You're only
Your
doing
Honor,
it.
so 3 minutes just for.
Okay. All right, we're ready to hear argument. Ready?
Who will be the Chief Justice this afternoon?
So,
Are your honors ready?
proceed when ready.
Mr. Chief Justice, Honorable Associate Justices, and may it please the court. My name is Insha Mitha, and I, alongside my co-counsel Alex Shaw, are representing the petitioner Wyatt Reed in the case at bar. My co-counsel is handling the contractual issue, while I will be focusing on the equal protection issue. This case centers on a fundamental constitutional protection against arbitrary discrimination. In Eisenstadt v. Baird, page 438, the United States Supreme Court reaffirmed that the government cannot intrude based on arbitrary distinctions on your marital status. As Justin Brennan said, the right of an individual, married or single, is to be free from government intrusion. This principle underscores that your constitutional rights do not hinge on your marital status. Yet here, Texas denies Wyatt Reed his constitutional right of parental recognition for no other reason than that he's choosing to remain unmarried.
Counsel, doesn't the state have a compelling interest in making sure that a husband and wife and contestants are held up?
Your Honor, petitioner's position is that the state does not have a compelling legitimate interest to justify their discrimination. We believe that respondent may contend that there is, as you mentioned, an interest towards marital stability. However, we believe that petitioner contends that they are misappropriately applying Bell v. Low Income Women of Texas, which states that a state must show a legitimate or compelling government interest. However, this argument is misplacing Bell's very narrow context. Bell specifically addresses the allocation of Medicaid benefits based on financial stability. Texas's exclusion of unmarried fathers from automatic parental recognition is not based on an economic necessity or an economic policy. The marital status of a parent is hardly relevant in determining whether or not this person deserves the fundamental rights afforded to them. The state does not have a legitimate government interest. What Texas labels as a legitimate interest is really a preference for a particular family structure. It's exclusionary. It's an exclusionary principle marked as policy. Instead of promoting child stability, it actively is disrupting it by depriving a child of a father that's committed and wants to be there. My roadmap is that we urge this court to reverse the lower court's decision for the following 2 compelling reasons. First, that the Texas law fails under constitutional scrutiny, and second, that Wyatt Reed has differentiated himself from a mere sperm donor. Turning to my first point, to establish this, we consider the 2 prongs under the Equal Protection Clause framework. The first prong is considering, does Texas discriminate solely based on marital status? The second prong does Texas have a legitimate government interest to justify that discrimination?
Is this statute really about marital status or is it about something else?
Yes, Your Honor. Petitioner contends that it is about marital status. The statute section in question is the Texas Family Code, Section 160-2015. This is reflected on page 10 of your record. This discriminates against unmarried men by limiting parental recognition in assisted reproduction cases only to married couples. Wyatt Reed is similarly situated that to a married father. He's demonstrated clear intent and he's taken on active parental responsibilities. Yet,
So we agree with what you're telling us. Wouldn't that mean that any person who want to be a donor can just jump into someone's life and say they want to be a father? What about the best interest of the child? What's so stronger as a donor in this instance? And how are we going to make sure that, you know, mothers and children aren't bombarded with donor requests for paternity?
Your Honor, could you clarify your question once more?
Right, if we go with what you're saying and saying, well, he's more than a donor and he should have parental status as the father. What's to stop any sperm donor from jumping in and saying, well, I want to be the father of this child too, whatever reason that they want to have.
The intent of parenthood is the key distinction, Your Honor. Unlike an anonymous sperm donor, Reed has financially contributed. He has attended prenatal appointments and he's signed a parenting contract. The law should not we are not asking the law to categorically treat all genetic contributors as just donors when there is an intent and involvement that indicate otherwise.
So would you say the distinction then, before the insemination occurs, the donor portrays an intent to be a father?
Yes, Your Honor. And what we're basing this off of is the precedent set by the Supreme Court in Larry v. Robertson in page 261. They affirm that constitutional protections can attach when an unmarried or an unwed father actively does fulfill parental responsibilities in one of three ways. It can be emotional, financial, or custodial involvement. Here, Reed actively satisfies each of these three ways. Reed has provided financial support as reflected on page 7 of the record. He's paid for maternity wear, he's paid for prenatal care, he's paid for a stroller, and he's paid for baby clothes. Continuing on page 7 of that record, Reed has provided emotional support through attending prenatal appointments.
But wasn't he not there when it mattered the most when the baby was born?
Yes, Your Honor, Reed was not there when the baby was born. However, we will urge this court to look at the precedent set by Larry v. Robertson, which takes a holistic approach to a father's involvement. Respondent may argue that Reed was not a committed father because of a few isolated incidents. However, we believe these incidents do not outweigh the consistent and meaningful involvement Reed has demonstrated throughout the record.
Didn't he stop paying? And she had to pay over $10,000 to remodel the study, and then he tried to break into her home at one point when he was drunk. I mean, how is having someone like that involved in the best interest of the child?
Your Honor, petitioner would like to direct your attention to the context of the incidents that occurred.
But where do you draw the line between, well, this is enough payment and this is enough involvement versus, you know, this person is not in the best interest of the child?
Could you clarify your question, Your Honor?
Sure. I mean, you mentioned earlier that he was involved a little bit, but in response to my colleague's question here, he wasn't there when it mattered the most. He tried to break into her house in a drunken rage. He stopped paying at some point. So where's the line drawn between, okay, well, this person should be a parent because they've given them enough money and enough involvement versus, okay, this person shouldn't be a parent because it's not in the best interest of the child as well as the guy, you know, he's not involved anymore. He's not paying and it seems to be dangerous according to what the facts are in this case.
Larry v. Robertson held that it does not require perfect fathers. It requires fathers that want to be involved and that have demonstrated it through the three different ways. The facts that you have brought up, Your Honor, did occur. Reed's business trip, however, petitioner stands is not an act of abandonment. He took this trip in order to promote and secure his business so he can maintain financial stability to continue supporting his child. Importantly, Your Honor, he communicated his intent and he obtained permission from Walker, as seen on page 8 of the record. Respondent may focus on the 7 weeks of reduced contact, but this ignores the 56 weeks of consistent support and involvement that came before. And as soon as Reed did return from his business trip and he was settled, he immediately resumed efforts to try to see his child through email, through phone call, and then eventually when he did show up. One isolated incident where Reed appeared intoxicated does not negate his fitness as a father. There is no evidence of repeated behavior or harm towards the child or the mother. Taken holistically, the record shows that this was an exception, not the norm. In fact, taken together, the record demonstrates that Reed did not just simply claim the title of fatherhood, but he embraced the roles and responsibilities that came with it entirely.
So similarly, with regard to sort of, where you draw the line, is there a temporal aspect to all of this? Could someone be absent for a number of years and then come back and decide they want to be a part of the child's life where they've given, the seed for the child?
No, Your Honor, this would not be permitted. Larry V. Robertson puts emphasis on that it must be someone that has tried to be part of the child's life soon after they were born. Respondent may also counter by asserting Reed is a donor under the Texas Family Code, section 160-102-6, which defines a donor as someone who provides genetic material without parental rights. However, their argument overlooks critical aspects of Reed's involvement and mistakenly overlooks the broader purpose of parentage laws. Parentage laws, time and time again, focus on parental involvement and intent rather than just your biological connection alone. Intent and conduct can override or refine just a statutory label, especially when your constitutional rights are on the line. Unlike an anonymous donor, Reed has engaged proactively, intending from the outset to have a meaningful and recognized parental relationship with JR. This can be seen when Reed is the one that initiated the contract that names him explicitly the father of the child. He is the one that suggested the idea of a contract, got a lawyer so he can try to cement his rights, and they both signed that contract, consenting to the fact that they intend Reed to be a father explicitly. This clearly shows his intent for being involved in the future of this child now and later on.
Did they send that before fertilization occurred? So does that matter?
Your Honor, this contract was signed before the fertilization occurred. And could you repeat your second part of the question?
Should it matter? Does it matter that they entered into a contract recognizing Reed as the father before she was even pregnant, or is it something that should be done after the pregnancy occurs? By the time they signed the contract, a child didn't exist yet. So should that matter in this analysis?
In this analysis, we do acknowledge that there is a temporal aspect. As brought up by the justice earlier, it does matter when the father is involved. Here, even though the contract was signed before the conception of the child, what this point is trying to show is that Reed was trying to be involved from the beginning, and he has consistently shown it throughout the period of the events that have occurred. So in the point that I am making, it might not serve as much of an interest here. In conclusion, Texas law fails to justify this discrimination under the equal protection scrutiny, and they're undermining the child's welfare by discouraging an active and committed father. For these reasons, we respectfully request this court to reverse the lower court's decision and reaffirm White Reed's constitutional protections. I would like to reserve the rest of my time to co-counsel.
Thank you, Kelly.
Thank you.
May I proceed, Your Honor? Mr. Chief Justice, Honorable Associate Judges, and may it please the Court. My name is Alex Shaw, and I, along with my co-counsel Insha Mitta, represent the petitioner, Wyatt Reed, in the case at bar. My co-counsel has addressed the equal protections issue, and I would now like to address the contractual issue. This case fundamentally concerns the validity of private agreements clearly demonstrating an intent to establish parental rights. Texas law respects clearly documented parental intentions, and the parenting agreement between Reed and Walker clearly demonstrate their intent to make Reed the father of the child. Parental rights are conferred not only through biology, but through the intention and commitment to provide for the needs of a child. I will address three main...
You're arguing that a contract established parental rights. Is there any kind of limit to what that contract can say? I mean, how does this take into account the best interest of the child when a parental right can be granted by contract and not by, being born to in wedlock? I mean, how is that? And how is creating it via contract not in violation of public policy?
Thank you, Your Honor. Yes, there is statutory basis saying that you cannot create a parental rights solely through a contract. However, there is plenty of codes which say that a parental agreement may confer those rights, and that will still be evaluated on the basis of the best interest of the child standard. And we will be arguing that this is what they actually created, despite their attorney mislabeling it as a contract. I will address three main points to support my argument. First, that private parenting agreements are generally valid under Texas law. Second, that Mr. Reed had a clear intent and involvement as a father. And third, that this agreement specifically meets the policy objectives laid out in the Texas Family Code. To my first point, private parenting agreements are generally allowed under Texas code. Texas law clearly recognizes the validity of parental agreements related to custody, visitation, and support, as shown under Section 153.007 of the Texas Family Code. This reads in the relevant part, to promote the amicable settlement of disputes between the parties, parties may enter into a written agreed parenting plan containing provisions for conservatorship and possession of the child, including variations from the standard possession order.
Well, let me reiterate my question that I asked your co-counsel. You just said the parental plan is to settle disputes, but here the child wasn't even conceived yet at the time that this was entered into. Does that matter?
I would say that you could, of course, enter into an agreement on either side. However, it's relevant in that this is going to demonstrate their level of planning, the level of commitment from both parties, and whether or not they enter into it before or after really intends to show what their goals are by entering this agreement together. Of course, they could sign it after, but I would be apprehensive to suggest that you should be giving away your genetic material without some sort of a plan in place beforehand, since it would be to the benefit of the child to have a plan before they are conceived.
So the Texas Family Code 153.07 says it allows parents, and if you don't have yet a determination here because of the other section of the Family Code that would qualify this person as just a donor and not a parent, then how can you argue for 153.007 to apply if by its very term because it has to be between two parents?
Well, the petitioner's stance would be that that relies on the assumption that he is just a typical donor, where this is a gray area of family law, where it is more than a donor, but not the typical father you would see. And using the best interest of the child standard, I believe it would be prudent to still look into this as far as what is the best interest of the child. And to correctly determine that, we must then look at the parenting agreement in order to see how that plays out.
But if you're able to enforce this contract, couldn't any sperm donor just come in and say, sign a contract and say, I'm this child's father?
No, Your Honor. Texas code does not allow you to just write contracts left and right and then give parental rights accordingly. What really happened was that a lawyer who they contacted told them that this is the way to do it, when in reality, by the characterization of the agreement they made, they really were forming something much more akin to a parental agreement, and that's why it's relevant to discuss this. The code clearly allows for the creation of parenting plans, and the courts are bound to at least consider enforcing such a plan if it aligns with the best interests of the child. In the case at hand, the trial court dismissed this agreement, suggesting that it was against public policy, yet the statute allows for the enforcement of such agreements as long as they align with the best interests of the child, or at least the consideration of these agreements.
Who determines best interest in this?
The judiciary would determine the best interests. Because their agreement dealt with parentage in addition to other commitments, their agreement is in effect a parenting agreement. It simply needs to be accepted for consideration by the court under the best interest of the child standard. This agreement is in line with the goals and requirements of a parenting agreement, and it is not an attempt to circumvent the law, but rather is a commitment to fulfill the responsibilities laid out in the parenting agreement. Texas Family Code 153.007C allows any remedy to be used in the enforcement of an order, and 153.007D allows the courts to modify a parenting plan. Therefore, the court would have ample opportunity to modify this agreement in order to best fit the needs of the child. Precluding Reed from utilizing this agreement and gaining his rights would go against the many benefits to JR which could be enforced by the Texas Code after hearing this agreement.
This all seems very sterile. Isn't a biological relationship more important than some, here are my contracted parents?
Of course, Your Honor. However, in the instance where two parents have entered into an agreement without a relationship, but with both a biological relation to the child, it becomes particularly prudent in determining why they entered into that relationship, what they both expected to gain from it, and what they expected to contribute to the child, because that's relevant in determining whether or not they're able to provide or who should be able to provide, Your Honor. My second point focuses on Reed's intention to parent and the active role he sought in the child's well-being. In a similar case titled Jordan C. versus Mary K., an unwed mother, Mary, conceived a child using sperm given by Jordan, and they disagreed on his role. Despite the fact that there was no written agreement regarding the extent of Jordan's role or his rights, his continued involvement evidenced an intent to maintain a parental relationship. While the courts emphasized the general necessity of statutory compliance with parentage laws, they went against this general rule and found that Jordan's parental conduct and clear intent strongly supported the recognition of his paternity, as stated by Justice King on pages 391 to 393. Furthermore, the courts emphasized that intention and involvement served the best interests of the child, and they granted Jordan his parental rights. Although Mr. Reed faced tremendous financial hardship due to the act of God cicada infestation which ravaged his business, he still made 5 prenatal payments and attended appointments until he was financially unable to do so because he had to go try and reinvigorate his business in order to provide for this support. While not the entire costs associated with bringing a child into the world, these payments demonstrated a good faith effort to be involved and an intention for Mr. Reed to fulfill his obligations as stated in the agreement they both signed.
Counsel, do you concede that there are any Hawley factors that don't favor you?
Could you please repeat your question?
See, there are any Hawley factors that don't favor your position on the best interest?
Could you please clarify what Hawley factors are, Your Honor?
The factors that go into determining the best interests of the child.
Well, Your Honor, I would say that the court could, of course, determine that there are factors related to Mr. Reed, but what we are arguing for is that the court won't even be able to make an accurate determination or any sort of determination unless we are able to bring this agreement into the courts to be evaluated. The discussion would be, should we accept things as they stand by a mother who has some tenuous feelings towards the husband because of this contentious litigation, or should we submit this agreement to the court for them to determine this on an even playing field? Financial hardship should not be a basis for undermining Mr. Reed's parental rights when his actions before and after the agreement's execution show a clear desire to support his child. The court may further demand from Reed any form of support it sees fit for his child under the best interest standard. However, this is only possible if you accept this agreement for further consideration in the courts. Just as the justices held in Jordan, we ask the court today to recognize Reed's parental rights and conduct in support of his claim for parental status. Now to my third point. This parenting agreement specifically meets the policy objectives laid out in the Texas Family Code. Texas public policy prioritizes children by ensuring that they are supported by both parents whenever it serves the best interest of the child. The Texas Code is based on this principle, and the parenting agreement in the case at hand was written to support this exact same goal. By dismissing this agreement altogether, the court would be taking away JR's right to receive support from both parents rather than modifying this agreement to meet his needs. Strict statutory compliance is not proper justification for throwing away the many benefits which could be ordered from either party under this agreement if it were to be entered into the court for consideration. In the case at hand, the lack of strict statutory compliance is overcome by Reed's clear intent to support the well-being of his child, as well as his subsequent actions taken during the pregnancy. We are not asking for an arbitrary allocation of parental rights to Mr. Reed, He's not some random donor or a one-night stand who is now seeking to meet a child he never intended to care for. Instead, Reed is JR's biological father, as stated in the parenting agreement, which both parties signed while planning to conceive this child, and he has made significant efforts and plans to provide for his child. Opposing counsel will likely say that Reed's actions were not in the best interest of the child, citing his traveling and failure to pay for the nursery. However, Mr. Reed was traveling in order to reinvigorate his business, in order to be able to provide the financial support once again, suggesting that his actions were actually in the best interest of the child. Furthermore, Walker is listed as a primary caregiver, and Reed asked her for permission to take this leave. And it would be unfair to suggest that Mr. Reed needs to go against the directives of the primary caregiver, especially when he's seeking to be able to provide the support he wants to give.
Counsel, did he breached the contract? I mean, he was supposed to assist in providing financial support, pay for the remodeling, which she ended up paying, I think, $20,000. Why should we uphold this finance contract you have?
Well, Your Honor, I would say that regardless of the contract, looking at it within the best interests of the child, he would still be precluded from giving the support down the road if we were to focus on the breach aspect of this. Furthermore, all the more reason this is simply a parental agreement, there was no proper consideration in the contract itself. It merely agreed on who would be providing the sperm, what rights that person would have, and who would be taking care of certain things such as the primary caregiver. There's no promise or exchange here. Really, it's an agreement on what both parties will be doing.
Texas. A lot of plowed into the right of people to contract, and if he made a contractual promise that he's going to pay and he didn't, and he breached it, why is it not Ms. Walker's right at that point to call, reach out and cancel the contract?
There is still substantial performance here, and if we allow this agreement to go up to the courts for consideration, then they are empowered by section 153.007C to use any remedy they see fit. However, if we focus on the breach, any sort of remedy that could be enforced to utilize to benefit the child would be precluded because this will never be up to the court to even decide. Opposing counsel will claim that Mr. Reed's one night of drinking and trying to see his child should preclude him from a parental relationship, when the reality is that people drink when they are upset, unfortunately, and his attempts to enter the house are evidence of this desire to see JR. Additionally, Family Code 153.004D1 states that only a pattern of family violence should preclude a parent from accessing their child. This is really one instance of vandalism, if anything, and hardly a pattern of family violence as required by the statute. This also demonstrates his commitment and intent, as Reed first attempted to contact her by email and then by phone, and then tried to get into the house after being denied and having the rights he thought they both agreed to taken away.
Because of what he did with this one event, your client is willing to enter into a family service plan where he would be monitored and have to be drug tested in the future.
Yes, Your Honor, and we are simply asking for this agreement to even be brought into the court for consideration, so that way we can make an unbiased, fair decision on an even playing field through the judiciary. Dismissing this agreement would send a message which undermines the good faith efforts of fathers seeking to be present and supportive in their child's life. Approving this parenting agreement for review would not create legal chaos, nor open the door for instability in the life of the child. It would simply allow the court a greater opportunity to act in the best interest of the child, rather than being cut out altogether. This parenting agreement will still require judicial oversight, and the court can still modify or enforce this agreement in any way it sees fit. This agreement outlines a clear plan for providing benefits for the child, and affirming the lower court's ruling would deprive JR of the benefits he was previously promised before his conception. Quite frankly, the court would be tying its hands if it refused to even enter or acknowledge this agreement for consideration in the courts. If the court is concerned about the implications of the decision on public policy, we ask that the court modify this agreement to best align with the needs of the child, rather than disregard the benefits Reed can and wants to give. The court may not even change anything, but at least they have considered the best interests of the child and allowed for a proper evaluation. Therefore, as parenting plans such as Reed and Walker's parenting agreement align with both statutory intent and Texas court's public policy, we respectfully request that this court reverse the lower court's dismissal and allow this agreement to be at least considered in court. Thank you, Your Honors, and I would like to reserve the rest of my time for rebuttal.
I'll hear from the respondents.
May I approach the bench? Your Honor, I'm sorry, let me restart. Mr. Chief Justice, Honorable Associate Justices, and may it please the court. My name is Nadia Butler, and I represent appellee Carolyn Walker alongside my co-counsel, Stephanie Aguirre. It's our client's position that declining to recognize Reed as father of the child would not violate the equal protection principle contained in either the state or federal constitution. We thus ask the court to reverse the holding of the lower court on issue 1 of this appeal. While the Texas Family Code does not necessarily guarantee Reed's parental rights, the statutory scheme still complies with the demands of the equal protection principle. This is because statutory schemes that run the risk of contravening the promise of equal protection must be tailored to serve a compelling governmental interest, a demand which the Texas Family Code satisfies. I will first like to start with discussing relevant state and federal case law before turning our attention to relevant provisions of the Texas Family Code. Bell versus Low Income Women of Texas, a 2002 Texas Supreme Court state case, provides a framework for analyzing equal protection claims that arise under the Equal Rights Amendment of the Texas Constitution, as well as for querying whether statutory schemes satisfy the compelling governmental interest requirement. First articulated in In re McLean, another Texas Supreme Court case, which the Bell Court cites, the analysis consists of 3 distinct steps. First, the court must decide whether or not equality under the law was denied because of a person's membership in a protected class, such as sex. If the court does conclude that equality was denied under the law because of a person's membership in a protected class, such as sex, then the challenged action cannot stand unless it is narrowly tailored to serve a compelling governmental interest. It is appellee's position that protecting children and ensuring the stability of the family unit meet this standard.
So if they're not married but living together, how's that going to affect it?
I don't believe in the present case that appellee and appellant are living together. Are you
I'm just assuming.
hypothetically?
Right. What's the compelling government interest to treat married and unmarried fathers differently? What if they're not married and living together? Is that going to, be affected by the statute?
In that case, the arrangement of cohabitation, I think, would be sufficient to establish paternal status. We would also dispute the characterization that this statutory framework discriminates on the basis of sex or marital status, on the basis of sex. 2 unmarried women seeking to raise a child would face the same problem confronting the appellant if one woman carried the child and while the other did not, suggesting that the statute applies equally to both sexes, i.e. to both unmarried men as well as unmarried women. And that's especially true when you consider the realities of artificial insemination, conception, and subsequent gestation.
If you would agree with me, to conceive the child, you need something from the woman and something from the man here. So doesn't the position that you're advocating for seek to put the woman's side on a higher playing field than the man's?
Not necessarily, Your Honor. And I think that in response to your question, Lair v. Robinson, a 1983 federal Supreme Court case, is particularly instructive. In Lair, it illustrates that the Supreme Court has upheld laws distinguishing between active involved fathers and uninvolved biological fathers. The court ruled that biological connection alone is not sufficient to establish a man's parental rights without taking additional affirmative steps to establish a parental relationship. So while yes, you do need genetic material from both the mother and the father, or from both a man and a woman in non-normative families, you also must take additional steps to establish a parental relationship. And we believe that appellant Reed has failed to do so.
How do you believe that he has failed to do so? He made payments he entered into an agreement with your client, and he hit hard financial times. And didn't your client essentially give him the green light to go ahead and help himself financially and go and chase fix this company with this cicada infestation. I mean, didn't she tell him, hey, you need to do what you need to do at this time? Wasn't that almost an estoppel argument from her, letting him go forward and take care of his financial? There was never anything said that this was going to affect his rights to the child, was there?
No, that was not said that it would affect his rights to the child, but it's important to note that appellant Reed established or obtained consent from appellee Walker to stop making payments only after he had already ceased to do so. Moreover, our client paid over $20,000 for prenatal services, while appellant Reed contributed less than $1,000. So 20 times less than what she contributed. Moreover, our client paid approximately $10,000 to remodel the study, while the appellant contributed nothing. Moreover, he was out of the country for 3 months, and this coincided with the birth of the child. He did not make he made negligible attempts to establish contact during the time he was out of the country. And once he was back in the country, he went to our client's house in a drunken rage and tried to break down the door. And the Texas Family Code on this last issue actually states that when physical violence or abusive force is directed at one of the parties, that is grounds for the denial of parental rights.
What if none of that had happened? What if he made all his payments, he'd been present and didn't try to break in to the residence? Would he have a claim?
Can you repeat your question, please, Your
What
Honor?
if none of this happened? What if he made all his payments, he was there for the child's birth, and he didn't show up in a drunken rage and try to kick down your client's door? Would he have a claim to parental right then?
I mean, I'm not sure, had none of those established facts happened, I'm not sure that we would be in the present dispute. Are you asking if none of those things had happened?
An unmarried man, I mean.
In that case, we believe that he would have made attempts to establish a connection with his biological child. And in that case, he would still have a claim to paternity and parental rights under the Texas Family Code. However, because none of that happened, it's our contention that he does not have claim to those rights. Returning to Lair explicitly states that the law may not subject men and women to disparate treatment when there is not a substantial relationship between the disparity and an important state purpose. The inverse of this statement is that where there is a substantial relation between differential treatment and the state's purpose, the law may operate as intended. The court went on to state in Lair that statutes which regulate familial relationships cannot be constitutionally applied in cases where the mother and father are similarly situated with regards to their relationship with the child. And again, we would reiterate that the mother and father are not similarly situated with regards to their relationship with the child at the center of this dispute. I would also direct the court's attention to Kaban v. Muhammad, a 1979 Supreme Court case that was concerned with the equal protection principles application in cases of parental rights disputes. In that case, the court held that it violated the Equal Protection Clause to grant the mother a veto over the adoption of a 4-year-old girl and a 6-year-old boy, but not to grant a veto to their father, who had admitted paternity and had participated in the rearing of the children, i.e., he had made sufficient attempts to establish a connection to his biological children. This case is obviously distinguishable because it concerns adoption, while the present dispute does not. But it's still relevant because the court made clear that if the father had not come forward to participate in raising the child, the equal protection principle would not preclude the state from withholding from him the privileges of vetoing the adoption of that child. This latter.
Do I understand your argument to be that the status here depends only on whether there's performance by the father, not whether as a per se parties can create parental rights by contract?
Under the Texas Family Code, performance is one of the most significant, if not the dispositive factor in determining whether or not one will have parental rights. And we believe that's especially true in cases such as this, where one relied on processes of artificial insemination to conceive, gestate, and birth a child.
Do you concede that a contract to create rights as a father, such as this document did, can be valid as long as there is performance?
Not necessarily, no. Performance would not be the only requirement in that case. The Texas Family Code provides us with procedural steps that have to take place in order for a man to establish that he is the father of a child when that child is born to an unmarried mother and an unmarried father.
Were those met here?
No, those procedural requirements were not met. Opposing counsel contends that the Texas Family Code only applies to appellant because he is an unmarried man. But as we made clear via our hypothetical involving two unmarried women, one of whom had carried the child and the other of whom had not, this statute applies equally to both sexes when considering the realities of conception and gestation and birth. It's our position that the Texas Family Code does not single men out for disparate treatment. Rather, it sets up a neutral framework for determining parentage, in which case both men and women must take affirmative steps to establish parentage and a parental relationship with the child. It is important to note that appellant Reed did occupy an uneasy position. He is not a sperm donor in the traditional sense, which is to say in the sense that the term is used under the Texas Family Code, but he is a sperm donor in the functional sense in that he furnished our client with genetic material so that she could conceive, gestate, and subsequently birth a child. Under Texas Family Code Section 160, subsection 102, a donor is defined as an individual who provides eggs or sperm to a licensed physician to be used for assisted reproduction, regardless of whether or not the genetic material are provided for consideration. Per Section 160, 102, 6C, the term does not include an unmarried man who, with the intent to be father of the resulting child, provides genetic material to be used for assisted reproduction by an unmarried woman. Rather, it defines a donor as an individual who produces genetic material used for assisted reproduction. It's important to note that the Texas Family Code discusses assisted reproduction in a clinical context. That is to say, it represents assisted reproduction as occurring in a medical institution.
So is that what distinguishes the situation? Is if it had occurred in a medical institution, then it would be a different ballgame?
Not necessarily. Had it occurred in the context of a medical institution, there would still be additional procedural requirements which would need to have been met.
What are those?
Those procedural requirements. So in the case of a man who donates genetic material to an unmarried woman, so that for the purposes of having a child, he must provide a letter to the physician stating the purpose, and that letter must be retained by the physician. That is stated in the Texas Family Code.
And that didn't happen?
No, that did not happen here. And we would also note that there are also other avenues via which an unmarried man, such as Reed, could have established his parentage of the child, such as by filing an acknowledgement of paternity with the county. Appellant Reed did not do that at all. In fact, he was out of the country during the time frame in which he would have been required to do so. It's important to note that a man who donates genetic material and is not the husband of the mother has no parental rights or obligations unless there is a written instrument stating otherwise. In this case, however, the written instrument is invalid because the parties did not adhere to the procedural requirements enumerated in the Texas Family Code.
How do you address the best interest factors here and the idea that a child would likely benefit from having two parents as opposed to one?
Ideally, Your Honor, yes, a child would absolutely benefit from having two parents instead of one. However, in this case, we believe that the appellant's negligible involvement in the child's life, as well as his behavior on the evening when he arrived at our client's home in a drunken rage and threatened to break down the door, leading her to call the police and have him escorted off the premises. We believe that those carry significant, if not dispositive weight, and that because of that, it is not in the best interest of this child for the appellant to have parental rights. We think that it would be the opposite of the child's best interest. Our client is more than capable of raising this child on her own. Indeed, she was able to pay $20,000 out of pocket for prenatal care. She is an established attorney and is established in her career. We think that she is more than able to raise this child on her own without appellant Reed's assistance. And we think that it would in fact be sexist to suggest that she is not capable of doing so. I would like to yield the remainder of my time to my co-counsel. Thank you, Your Honors.
Thank you, counsel.
Mr. Chief Justice, Honorable Associate Justices, may it please the court. My name is Stephanie Aguirre, and I represent the appellee alongside my co-counsel Nadia Butler, who just discussed the equal protection issue. This case is about whether a private contract can override the clear statutory framework that governs parental rights in Texas. The answer is no. The lower court correctly held that the parenting contract between Ms. Walker and Mr. Reed is invalid and unenforceable for three primary reasons. First, Texas law does not allow private contracts to establish parental rights. Second, the contract violates public policy by circumventing statutory procedures. And third, the agreement is not in the best interest of the child. For these reasons, we respectfully ask that this court affirm the lower court's ruling. On my first point, Texas law does not permit private contracts to establish parental rights. Texas law provides clear rules for determining parentage, rules that cannot be overridden by private agreements. Under Texas Family Code Section 160.201, the father-child relationship is established between a man and a child only through an unrebutted presumption of the man's paternity of the child, marriage, adoption, a court order, or assisted reproduction between a married couple. This is governed by Section 160.204 of the Texas Family Code. Nowhere does.
Why isn't the agreement entered into here an acknowledgement of paternity signed by the mom and dad?
Because it doesn't meet the characteristics of an acknowledgement of paternity. That is actually specified by the Texas Family Code, and it states that there must be a statement that the parties recognize that this is essentially the equivalent of like a judicial order, that also there must be a recognition, or there must be a statement of whether genetic testing has been conducted, and if not, why not? There's like a lot of admissions and formalities that are required, and this agreement completely lacks all of them, so it cannot be considered such.
What can be considered a parenting plan that can be enforced by the courts?
Actually, Your Honor,
It's the best interest.
it cannot be considered a parenting plan, which I plan to discuss later, but to talk about it a bit more right now, an agreed parenting plan under the Texas Family Code requires that the plan be submitted to the court for approval, and the court has to render an order on it for it to actually be effective. This completely invalidates the arguments that are proposed by the appellants, because this was never submitted to a court, and therefore it never had legal force. Nowhere does Texas law allow parentage to be created simply by a contract. This court has consistently held that parental rights cannot be assigned or manufactured through private agreements on their own. In the case of N. Ray ESS, the courts refused to enforce an agreement in which a father attempted to terminate his parental rights. Yes, Your Honor, I apologize. Bad habit of mine. The court determines that because the father in ESS did not sign an affidavit of relinquishment as required by the statute, the agreement was not legally enforceable and it violated public policy. The same reasoning applies here. Just as a private contract alone cannot take away parental rights, a contract cannot be used to create parental status. Notably, the parties in ESS took significantly more procedural steps than Mr. Reed and Ms. Walker did here, as a settlement agreement in ESS was presented to and approved by a trial court. The agreement between Ms. Walker and Mr. Reed was never even submitted to a court and certainly not ordered upon. Therefore, under the ESS standard, the legal requirements for an enforceable agreement were not met. And because this parenting contract attempts to bypass these legal requirements, it is invalid as a matter of law.
But isn't Mr. Reed trying to bring it to court now for approval?
But this is essentially taking place after the fact. He's trying to argue that this is enforceable as a matter of law, but he can't also simultaneously get it enforced and then argue it's enforceable. That would have had to take place much earlier. On my second argument, the contract violates Texas public policy. Although the parenting contract may reflect the parties' private intentions, parentage in Texas is governed by statute and not by private agreement. The Texas Family Code provides the exclusive framework for establishing legal parent-child relationships.
Isn't the best interest of the child is the primary consideration in establishing status as a parent?
Absolutely. I will talk more about that's actually my third argument. Thank you. And they have consistently refused to allow private contracts to supplant that statutory structure. Again, in ESS, the courts held that an agreement to terminate parental rights was void as against public policy. And they emphasize that individuals cannot alter the legal status of parenthood through a contract when those agreements conflict with the statutory scheme and the best interest of the child. Also in N. Ray Sullivan, the courts rejected attempts to assert parental rights outside of the procedures mandated by the Texas Family Code, and they reaffirmed that the statutory scheme must control these determinations. Even mutual agreements cannot override public policy. As demonstrated by ESS, family law contracts must yield to statutory and public interest considerations, especially when the rights and welfare of a child are at stake. Ultimately, enforcing this contract would undermine the statutory safeguards that are designed to protect children and regulate parenthood in Texas. It would sidestep the legislative framework, invite inconsistent applications of the law, and diminish the role of judicial oversight. If private parties could unilaterally confer or strip legal parentage by contract, the courts would be reduced to mere enforcers of personal arrangements rather than guardians of the child's best interest as the Family Code requires. Determinations of parental rights belong to the courts, guided by statute, and not to private agreements that are driven by the adult expectations. On my third argument, the contract fails to meet the best interest of the child standard. Texas courts have a duty to uphold laws that protect children and ensure stable parent-child relationships.
Basically fulfill those two interests that you were talking about, where you have two people who are showing through their agreement that they want to engage in a parenting relationship with it or for the benefit of a child, and therefore it would seem to serve those purposes to enforce or find that this agreement is valid.
Actually, Your Honor, we find the contrary. While they are arguing that Mr. Reed was trying to demonstrate his intent, that only took place the first couple of months of the pregnancy, and then he virtually disappeared off the face of the earth to Ms. Walker. And once he encountered financial hardship, he basically, like when the times got tough, he got going. He went out of town on these international business trips that must have cost an enormous amount of money, for one. And this is funds that could have been allocated at least partially towards supporting the birth of his child, which should have been a priority. We aren't even sure that these business trips were absolutely necessary to recovering his business. Additionally, even if he couldn't provide financial support, he could have provided emotional or mental support, and he could have been present for the birth of his child. The last message he sent to Ms. Walker was sent 2 weeks prior to the birth of the child. He didn't reach out for another 2 weeks after the birth of the child, or no, excuse me. He didn't return back to the United States for another 2 weeks after the birth of the child. And then he took another 2 weeks after that to even reach out to Ms. Walker and ask to see the child. This does not demonstrate an intent to be an active part of the baby's life. And actually, they discussed a bit earlier, but in the case of KB versus NB, this is one of the factors that the courts took into consideration when determining if a substantial relationship existed between the parent and the child. They weighed whether the father was present at the birth of the child. This is clearly not present here. And we believe that this demonstrates a lack of intent.
Who decides, who weighs the factors you just talked about?
The court does, Your Honor.
The court does or the jury does?
So I believe that in the Texas Family Code, it states that it's ultimately the court's responsibility to determine what the best interest of the child is and to like ensure that parenting agreements or agreements pertaining to the parent-child relationship are in the best interest of the child. So,
If we go back and look, I mean, didn't Mr. Reed pay for baby clothes, I guess a carriage, and intended to pay for these other things before he fell on hard times? And didn't your client say she was fine with his absence because it made her closer to the baby? I mean, doesn't it seem like she was okay with this? I mean, he fell on hard times, he had to travel, and I mean, it seemed like they were working things out, and then she got mad at him because he couldn't, stop making some other payments. And wasn't his intention to always be involved with this child?
I believe that might have been his initial intention to be involved with his child, but I believe that he also made a valid judgment once times got hard about what his priorities actually were. An international plane ticket costs at least $4,000. And he made less than $1,000 in payments to Ms. Walker. He bought some clothing and a baby carriage, which maybe comes out to a couple of hundred. She paid $20,000 for her labor and delivery out of pocket. She paid $10,000 for the remodeling of the nursery, along with all the other expenses that she's had to foot all by herself. This does not demonstrate a substantial relationship or intent to be a part of the child's life. Texas Family Code Section 153.002 states the best interest of the child shall always be the primary consideration of the court in determining the issues of conservatorship and access to the child. Also, 153.001 specifies that Texas public policy must assure that children will have frequent and continuing contact with parents who have shown the ability to act in the best interest of the child and provide a safe, stable, and non-violent environment for the child. The record demonstrates that allowing Mr. Reed to have access to JR would violate public policy. Upon receiving Ms. Walker's legal correspondence informing Mr. Reed of the breach of contract, he went to her residence in a drunken rage, demanding to see JR. Then he attempted to break down the door and was forcibly removed by the police. His own actions demonstrate that he has not shown the ability to act in the best interest of the child, and he cannot provide a safe, stable, and nonviolent home. Furthermore, his inability to make payments, as we just discussed, towards the support of JR demonstrates that he can't even provide financial support at minimum. And then we also discussed that he didn't provide emotional or mental support, and that whenever he returned to the United States, seeing his child wasn't even his priority.
In this situation, though, we're not multiple years of neglect and failure to show up and multiple acts of drunken rage or violence. We're talking about a couple of month period, a couple of payments missed, and one episode. And we're dealing with something as important and fundamental as parental rights. Why shouldn't there be more, at least go to a judge or jury to make this determination?
So, Your Honor, I believe, you characterize this as like this was one incident where he flew off the handle essentially, and these were a couple of months. But all of these factors, whenever you view them individually, they may not seem important. But whenever you view them in the broader context, the entire picture, this demonstrates a man who has not been an active part of his child's life and who hasn't demonstrated interest in being an active, productive, or fulfilling member of his child's life. Actually, furthering the financial point, he could have taken up a second job to try to support his child during the pregnancy during the actual pregnancy, whenever these insurmountable expenses are coming up. There are alternatives and there are ways for him to be able to contribute, even if it's difficult or non-ideal. He also could have maintained consistent contact, and he was definitely aware of the due date of the baby, because I think all adults are aware that a pregnancy takes approximately 9 months. He attended the earlier appointments with Ms. Walker, and he was more than aware of the time that the baby would come. He made no attempt to be there, and that is extremely important. And actually, as shown in KB versus NB, that's a factor that the court uses. And so this needs to have much consideration in this present case. On my last points, the contract is unenforceable due to Reed's failure to perform. So even if this court were to consider this a contract valid of enforcement, the parenting agreement fails due to Reed's material breach. He failed to pay for prenatal expenses as he promised. He failed to contribute financially in all of the regards that we've discussed. He was absent for the majority of for much of the pregnancy. Texas courts don't enforce contracts when one party fails to perform. And since Reed failed to fulfill his obligations, he cannot demand enforcement. I would also like to address some of the arguments that were made by opposing counsel. Excuse me. First, I would like to point out that appellants actually misstated the factual record regarding the timeline of the agreement and the artificial insemination. In the factual record, it states that the parenting agreement was signed after the insemination had already successfully taken place. This actually is an important distinction. Under section 160.754 of the Texas Family Code, they discuss gestational agreements, and they state that a gestational agreement, for it to be valid, it must be signed by the parties prior to the insemination taking place. And if we are to look at the laws that the legislature has enacted for specific reasons, they obviously had a concern in trying to regulate the way that this family law works regarding the procreation of life. Then we have to see that this is an important step that did not take place here. They created a child and then created an agreement subsequently. And this is an important distinction that was failed to be noted by the appellant. Additionally, they cited the Lair case in a lot of their arguments, and they essentially argued that this was comparable. But I would argue that this is distinguishable because they failed to establish the substantial financial, emotional, and custodial involvement of Mr. Reed in relation to JR. This has almost no similarities to that situation because he wasn't present in all of the ways that I have previously discussed. Additionally, based upon the arguments that I presented, I would like to point out that parenting agreement is not enforceable. As we discussed under the Texas Family Code, a parenting agreement has to be submitted to a court, and the court has to make an adjudication upon it and sign it, which essentially creates an order for it to be enforceable. They can't simply sign the document between the two of them and then declare it a legally enforceable documents that the court has the power to compel one party to take certain actions. That's not the way this works.
Why can't the court just look at it now and determine, whether to approve it or not or modify it?
Well, I believe that this would essentially, that's outside of the discretion of what they are asking for or what they are entitled to ask for in this situation. That's asking for relief that they should have acquired much earlier in this proceedings. Essentially, they did argue earlier in this hearing that a rigid interpretation of the statutes would be detrimental, but I argue quite the opposite here. Statutory compliance is essential because it ensures that the public interest that the legislature had in mind is protected. And for these reasons, I urge you to hold that this contract is invalid. Thank you.
Bailiff, may I ask how much time we have left on our side? Thank you, Your Honor. Thank you, bailiff. Your Honors, may I proceed? I will first address the constitutional argument before addressing the contractual issue. Opposing counsel incorrectly contends that this rule discriminates solely based on marital status. However, this marital discrimination first requires discrimination on the basis of sex. To illustrate this point, consider two mothers, one married and one unmarried, both equally related to the child and mothering a child. Their parental rights are exactly the same because marital status doesn't become an effect to be discriminated upon until after first discriminating on the basis of sex. Consider two fathers, both equally related to the child, one married and one unmarried. While that may not be the case for mothers, all of a sudden it becomes relevant because these fathers are now being discriminated on by the basis of sex. Opposing counsel incorrectly contends that two mothers would face the exact same treatment. And while that might be the case in their scenario, that's not substantially similar to our scenario in which the mother and father, Mr. Reed, was in fact related to the child. Two married mothers would inherently have one mother who is more related to the child and one mother who is not related to the child. I would now like to go to the contractual issues. In regards to when the agreement was signed within 3 days of the confirmed conception, and that was due to the procurement of an attorney. Regardless, this plan was formed because of the future things that would be occurring and their desire to enshrine that in some sort of an agreement. Appellee contends that our client seeks automatic enforcement, and this is blatantly false. This is not what we seek. We simply ask that this agreement be considered at all. Considering that this agreement may yield the exact same result or a result only marginally different, that's fine, but it at least opens the door to garner benefits from Reed. Dismissing this agreement altogether would be disregarding the potential benefits which could be put in place or enforced by Reed in order to benefit the child. Affirming this dismissal disregards all of these benefits, which could simply be gained if we even allow this agreement to be considered whatsoever. We are not seeking automatic enforcement. Second,
It seems the Appellee's Council mentioned multiple times that there were provisions in the family code that could have been used, acknowledgements and other types of agreements that proper procedures have been followed. Your client wouldn't be in this position.
Thank you, Your Honor.
Follow those procedures. Why should we go ahead and give them the benefit of those?
Thank you, Your Honor. I would like to point out that an acknowledgement of parenthood requires the consent of paternity, requires the consent of a mother. So now, after this agreement was signed, it's now contentious and it would be difficult to obtain that. Furthermore, had their client correctly advised them to sign a parental acknowledgement of paternity, then we would not be in this instance, in this litigation at all. It's a but-for cause that their attorney misled them, because if they'd signed the exact same type of agreement or entered an agreement with the same intent as an acknowledgement of paternity, then we wouldn't be having this issue.
That's not Ms. Walker's problem, right? That's the attorney.
That is the attorney's fault, Your Honor, but using the best interest of the child standard, it's important to consider the effects and the realities of what they were attempting to do. And it would be unfair to the child to say we should disregard any benefit which could be enforced if we at least acknowledge this agreement by fixating on the fact that they were misled by counsel they hired while attempting to provide those benefits to the child.
What benefits? I mean, he's not there. He's not paying. He's seeing another woman. What benefits are you talking about at this point?
I would
give your Mr. Reed's actions.
And I would like to answer your question in case I do run out of time. I would say that regardless of whether or not he's seen another woman while overseas trying to reinvigorate his business is irrelevant to whether or not he's able to provide these rights. They had no sort of emotional or relationship as ascribed there. Also, the benefits he's seeking to give don't have to be anything grand. The court might just say he needs to pay money to her every month. The entire point is that if we dismiss this agreement altogether, we're losing the opportunity to even enforce those types of benefits. And when he came back, he first tried to contact her by email. He tried to contact her by phone, and she continuously turned him away from trying to even see his child. So it'd be improper to say that he's absent when he is trying to enter and be present in his child's life. Also, they say that a contract cannot override the statutory guidelines, and we're not seeking for that. There is case law which says that we don't always have to follow the statutory guidelines because that is the power of the best interest of the child standard. So it is important to at least consider this agreement rather than throwing away the wealth of resources which could be gained from Mr. Reed if we simply even open this agreement to be considered by the courts. Thank you, Your Honors.
Counsel?